Hello and welcome to Chapter 4, Civil Liberties, from the American Government Textbook, 3rd edition from Open Stax. So we're going to be talking about civil liberties in this video. So you can see here from the COVID pandemic, when the government shut down a lot of activities, of course, religious institutions fought that, and we're going to talk about such things. So, what are civil liberties and civil rights? So, in this chapter, we're talking about civil liberties, but in the next one, we'll talk about civil rights. But there is a distinction between them. So, civil liberties are limitations of government power that are designed to protect freedom. So, they are meant to make sure that you're protecting your freedoms. Civil rights, on the other hand, are constitutional guarantees that the government and government officials will treat people equally, regardless of what class or race or gender or ethnic origin or religion. So, since this institution of this country, there has been some civil rights violations of particular individuals based on their race or their gender. And of course, we've had to do over the years since the founding of this country, we've had to do our best to make sure that those civil rights are guaranteed to all races and gender, and of course, religion. So you can hear some activists. So actually, as of this recording of this video, not too long, Sidney Potter, here on the left-hand side, recently passed away. Of course, you have Harry Belafonte and Charleston Heston on the right. Lincoln Memorial Steps during the March of Washington in 1963. So, civil liberties and the Constitution, the first part. Most important civil liberties are protected in the Constitution. Of course, remember our civil Bill of Rights. Of course, the protection of civil liberties was a major implication of the Constitution. We wanted to make sure that people's liberties were protected. And of course, the requisite number of states did not ratify the Constitution. So, of course, there were several things that would need to be included in the Constitution to protect civil liberties of the individuals. So, Article 1, Section of the Constitution contains the protection of civil liberties, prohibiting Congress from doing such things, right? So, no passage of bills of attainder. So, a bill of attainder is a law that punishes a convict or punishes a person for a crime without a trial. So, you really, in the United States, you can't pass a bill that says that, oh, we're going to punish this particular individual and not have a trial. You need to have a trial in order to punish an individual. So that's different, though, than you can arrest somebody, but you can't fully punish them, right? You can't say, we're going to sentence you to 5 years in jail or 5 years of probation without actually having a trial. You need to have a trial in order to fully punish someone. So there can be some people, though, who get arrested, and because they can't post bail or the judge says no bail into the hearing, they can sit in jail. But that's different than from, saying, well, that person's going to be in jail for 10 years, but there's no trial. So you do need a trial. No ex post facto laws. An ex post facto law is a law that takes effect retroactively, so you can't do that. And there's no suspension of the writ of habeas corpus unless required for public safety. So the rate of habeas corpus, so you can't do that. You can't be unlawfully detained, so you can't be just detained for no reason. President Lincoln actually did habeas corpus during the Civil War. Only in extreme cases can this be done. So the amendments to the Bill of Rights. So there has been some from the Bill of Rights contains the following protections of civil liberty. So the First Amendment, the right to freedom of religion and speech, the right to assemble and to petition the government for renderance of grievances. So under the First Amendment, we do have freedom of religion and freedom of speech. However, that does have a limitation. So when it comes to speech, right, you just can't say whatever and do whatever you want. There are some limitations. So, for example, you can't get up in the middle of a movie theater and scream fire when there is no fire because you're putting people in danger, and that's going to get you in trouble. You just can't be slandering individuals for the fun of it and harm them. And so there is limitation to your speech, right? So, and as I like to say, right, you do have freedom of speech, but you don't have freedom of consequences. Freedom of religion as well. You can, you can choose to join a religion or not. You can peacefully assemble, or if you want to petition the government, to peacefully, that you can do that. The Second Amendment, the right to keep and bear arms, and that has been a discussion, a topic, because there are some states in there's some states in the United States who truly, really allow individuals to walk with firearms or with open carry. Other states are more stricter, and so that has been a topic of debate. The Third Amendment, the right to not house soldiering during time of war. So, of course, in today's age, we really don't see that. We don't see U.S. soldiers coming into someone's house and staying there. That was really meant because during the Revolutionary War, British soldiers would come into people's homes and just sit there and just stay there, without the people's permission. And so they wanted to prevent that from happening. Fourth Amendment, the right to be secure from unreasonable search and seizure. So if a police officer or some government official is going to search you or seize, they need to have the proper warrants to do so, the proper measures. Fifth Amendment, the right in criminal cases, including due process, is a right to not to testify against oneself. So if you ever hear I plead the fifth, that usually means I'm not going to testify against myself. I'm going to keep quiet. Sixth Amendment, right, the right of a speedy trial, right? So you have the right to a speedy trial, so you just can't be sitting there waiting forever. Seventh Amendment, the right to a jury trial in civil cases. Eighth Amendment, the right not to face excessive bail, excessive fines, or cruel, unusual punishment. So that's always up for debate, because you have heard of cases where a judge says, "Oh, your bail is set at $1 million or $2 million," and of course the person only has to usually post 10% of that. But of course, there's also no cruel, unusual punishment as well. The Ninth Amendment, all rights are retained by the people, even if they're not specifically enumerated by the Constitution. And the 10th Amendment, all powers not delegated to the federal government are retained by the states or the people. So Incorporation, so after the ratification of the 14th Amendment, after the Civil War, expanded, of course, to expand the protections of the Bill of Rights through Incorporation. So you can see here President Lincoln right on the right-hand side. So categories of rights and protections. So, you can see here where, you have criminal and individual, Second, Third, and Ninth Amendment. The First, Seventh, and Eighth kind of, mix in with procedural and, of course, criminal. So First and Sixth Amendment, there you can see how they're intertwined together. The First Amendment states Congress should make no law. So again, it's very important to know that as an individual in this country, you do have your rights. You do have your freedoms. But again, you have to make sure that you don't overstep the boundaries of the freedoms that you have. Again, with speech, you have the freedom of speech, but you don't have the freedom of consequences. And so if you say or if you say particular things to certain individuals, or you say certain things in certain environments, that may lead to some type of repercussions for you. And again, not everything may be protected by the First Amendment, even though you may believe so. So the First Amendment consists of the following clauses that protect civil liberties. So the Establishment Clause, right, prohibits the government from establishing a state religion. So the government, federal or state, cannot establish a state religion. So, for example, the state of Oklahoma or the state of Illinois or Hawaii cannot say, Catholicism or Presbyterianism is going to be the official state religion. They cannot do that. So you cannot do that. And of course, the Free Exercise Clause prohibits the government from preventing or controlling religious practices. Of course, the Free Speech Clause prohibits the government from suppressing or restricting most forms of speech and symbolic speech. So this Free Speech Clause, so of course, again, there's prohibition from the government from suppressing or restricting most forms. So what that means is, for example, if someone wants to come into a university and it's a Nazi group, and they're going to spill hate and say all these things about certain individuals, then of course the university has every right to deny a permission for that particular group to come in and have that conversation. However, if a group wanted to come and talk about culture and race in a very academic standards, the university cannot say no, we're not going to have that. And of course, the free exercise clause prohibits the government from, I cannot prevent or control religious practices. So, for example, if I'm teaching in front of a class as a state employee, I cannot lead in a state institution. So, for example, if I'm teaching at a state institution like a state university or a community college that's public, right? I can't get up in front while I'm teaching and lead the class in prayer. And so I cannot do that because I'm exercising a religion, and in my status, I am seen like I am favoring a religion over the other. But I cannot prohibit if students want to go outside and have a prayer session on their own amongst themselves. I cannot prohibit that from happening if they want to do that on the side. So you can see here a portrait. The second part, the free press clause, of course, prohibits the government from restricting the right of press. So, the government cannot suppress a particular, news organization. The free assembly clause prohibits the government from restricting peaceful assemblies. So if there is a peaceful assembly, the government just can't shut it down. But there has to be some reasonable cause to shut that assemble down. The right to petition clause permits individuals or groups to petition the government. So of course you can, write or call out an elected representative or official. Freedom of expression refers to the rights protected under the First Amendment: free speech, free press, free assembly, the right to petition. So speech includes written communication, online as well, as well as symbolic speech, wearing certain attire. So under the First Amendment, the burning of the American flag is protected under the U.S. Constitution, under the First Amendment. Although it's controversial and some may not like the burning of the American flag, the courts have found that is constitutional. So there's always a boundary. However, what is not protected by the Constitution is, again, as I mentioned, is if you get up in the middle of a movie theater and you hear a fire and everybody starts running and there is no fire, that of course is not protected. Freedom of expression, right? So how do you express yourself as long as people don't find it to be offensive or hate speech? So think about this question, right? The framers of the Constitution were originally reluctant to include protection of civil liberties and civil rights in the Constitution. Do you think this would be the case if the Constitution were written today? Why or why not? So think about it for a minute and answer that question on your own. So of course, over the years, there has been some controversy. Some of the most notorious cases regarding free exercise clause involved the Oregon bakery store who refused to bake a cake for a lesbian couple, citing their religious beliefs. The couple were awarded $135,000 in damages. So over the years, and of course there was a similar case, and the Supreme Court ruled in the favors of the bakers' rights. So there's this famous case of, if a gay couple individual, a lesbian, go into a bakery and say, hey, we want a particular cake that has us both, and the bakery shop says, well, we can't do that because it goes against my religious beliefs. The courts have found that, the bakers have the right to refuse if they say it violates their religious beliefs, to not bake that cake. And the thing in capitalism, of course, if they don't particularly like that, you can always refute and go to a different bakery. But of course, we have to be careful of what we step in, because if we allow this one to happen, then what's the next thing that's going to happen if it's just always going to be about religious beliefs? So there has to be some careful evaluation as to what is the free exercise clause and how far does that go. And of course, we let the courts decide that. Again, the flag burning is protected by the U.S. Constitution. The Supreme Court has allowed laws that ban threatening symbolic speeches. So again, although the burning of the American flag is protected as freedom of speech, because it's not the same as when the Klan burned crosses. In the heyday of the Ku Klux Klan, they would burn crosses in front of African American homes as a symbolic of hate towards them, and that they were coming for them if they did not leave, or they were coming for them soon. So the burning of the cross by the Klan was deemed as a threatening hate symbolic speech. Of course, we see here, the Surgeon General's warning. The Second Amendment states that all well-regulated missions should be necessary to secure free state the right to bear arms. So the Second Amendment provoked little controversy before the Civil War, and of course after the war, many states introduced laws to prevent former slaves from possessing or carrying firearms. Beginning in the 1930s, governments introduced laws restricting ownership and the sale of certain types of firearms. And of course, this, even to this day, has led to a lot of discussion about what is the right to bear arms. Should individuals have right to certain category of weapons or not, just for the sake of their Second Amendment protection? So in 2008, the Supreme Court found an individual right to bear arms for traditionally lawful purposes, such as self-defense within the home. And so, of course, that was in 2008. In 2010, the Supreme Court incorporated the individual right to bear arms into the Due Process Clause of the 14th Amendment. So, of course, within that state's laws regulating firearms could violate the constitutional right. So, of course, here you see that there are certain places, of course, you cannot carry your firearm. The Third Amendment prevents the federal government from quartering soldiers. This was, of course, during the times where British troops would just house, there would be American colonists would be required to house British troops in their homes. And so the Third Amendment has not been incorporated, to the states because the Supreme Court has not considered this issue. So really, this was meant because of the happenings of the American Revolutionary War. They just wanted to make sure, the framers wanted to make sure that this didn't happen again. So as of the founding of the Constitution, we have not had this amendment go up to the courts for being challenged, because we don't have soldiers, telling us to let them, house themselves in our own homes. Of course, the Fourth Amendment rights people to be secure in their persons, houses, papers, and effects against unreasonable searches. So a police officer cannot just come into your house without a warrant and just take your stuff, right? So they can't do that. The Fourth Amendment issues with equitable application. Of course, you need a search warrant. Issues often arise in gray areas. So there's always that gray area of whether or not it's okay, or do you need a search warrant. Police can search and seize people's or property without a warrant if the owner or renter consents to the search, if there are reasonable expectations that evidence may be destroyed or tampered with before a warrant can be issued. So if the items in question are in plain view of government officials. So, for example, if an official is about to arrest you or is searching or is looking, and they see clearly that in plain view of evidence that is important to the case, or that they fear that you're going to destroy or tamper with, in a particular case, they have the right they have the freedom to obtain that such evidence, because they fear that since it was in plain view of the government official. There has been also controversy, in particular of law enforcement with no-knock warrants based on risk of evidence being destroyed. And of course, this has been a very controversial type of warrant. So what a no-knock means is when the police officer, usually when police officers or government officials come and knock on your door, they knock on your door saying, announcing themselves, hey, it's the police, or, really loud, it's the police. Come out with your hands up, and we're going to come in, and we have a warrant, and they show you the warrant. And so they make loud noises so they're coming. No knock warrants is basically they don't knock, they just go in because they fear that if they know you're coming in, you're going to destroy evidence. However, that was very controversial when Breonna Taylor was killed in a mistaken, she was killed mistakenly. And so, of course, there has been undergone significant scrutiny whether or not no-knock warrants are justifiable when innocent people are being killed. The Fifth Amendment states that no person should be held to answer for capital unless presented an indictment of a grand jury. And of course, the military is a different case. If it was a case in the military, they have their own courts. So that's a different type of case. So the Fifth Amendment addresses civil leaders of persons accused of a crime, the right to indictment by a grand jury in a felony case, protection against double jeopardy, so you can't be prosecuted twice for the same crimes. This, of course, does not regard the same thing with some subsequent civil trial of the same conduct. So, for example, what double jeopardy really means is, for example, I cannot be tried twice in criminal court for the same crime. However, that doesn't mean that after the criminal case, I can't be going to the civil case. So if you go back to, recall the O.J. Simpson trial in the 90s, O.J. Simpson was found not guilty of murder, but then he went to civil court. He got taken to civil court and he got sued. That can happen. The right against self-incrimination. So you can't, you need to, and of course, Miranda versus Arizona was a very famous case. Police officer needs to read your constitutional rights, and of course the right to due process. So, of course, the Fifth Amendment prohibits the government's taking of individuals' property through eminent domain or civil fortitude without such compensation. Both have been frequent tools of government law enforcement. So, civil forfeiture is when a police officer pulls you over and say, for example, you have $20,000 in cash, and they see that, they can take that money away because they may seem that it's deemed that it's for drug money or for dangerous purposes. Eminent domain, of course, is when the government says, hey, we're going to give you $100,000 for your home because that's the value of it, because we're going to build a park or we need it for government sources, for government sided projects. The Sixth Amendment, of course, in all criminal cases, the accused shall enjoy the right to speedy and public trial. So here, of course, was Clarence Gideon. The Sixth Amendment of Civil Liberties addresses the protections for the court, trial including speedy trial, public trial, a jury from the state where the alleged offense occurred, the right to receive notice of accusations, the right to confront witnesses. And so, of course, another important thing is that a public defender represents someone who is unable to pay for a defense. So think about some of the questions, some of the content that we reviewed, and ask yourself, in which areas do you think people's rights and liberties are at risk of government intrusion? Why? And which solutions would you propose? So here, of course, you see a typical court in the United States. The Seventh and Eighth Amendments address the right. So the Seventh Amendment addresses the rights of individuals engaged in civil litigation, so not court. The Eighth Amendment states excessive bail should not be required nor excessive fines for criminals or public inflicted. So of course, that has been a very the cruel and unusual punishment has been in debate because people have said that the death penalty is a cruel and unusual punishment, but others have not said that. So that, of course, is up for debate as well, the Eighth Amendment. So compared to other countries across the world, the United States has the 12th highest per capita rate of executions in the world. compared to other countries. You can see here who has a higher rate of executions. The Ninth Amendment states that certain rights shall not be intruded to deny or disparage others retained by the people. Of course, that's what it says. In the 10th Amendment, the powers not delegated to the United States is, of course, reserved to the states. So, of course, that's where you see whatever the government does not say, it gives a right for the states to, to dictate themselves. So, for example, in the Constitution, you really don't see anything about the right to guarantee of education. That was left up to the states. That's why every state has a different they have similar, of course, education systems in K-12, but certain states allow for different aspects in education. So education is one topic that, of course, was left up to the states. Most of the criminal cases, criminal cases, were left up to states. Of course, there are some protections from the federal government regarding criminal cases and civil cases, but of course, the states were left to do the majority of the work. And so, of course, again, whatever the federal government was not given powers to, it relies on the states to make such laws. The right to privacy, right to the United States Constitution does not include any words of right to privacy. So that has been there, right? So there is, of course, some provisions where several provisions within the Bill of Rights indicate the framers may have viewed privacy as a vital right. So you can see here some of the amendments. So of course, in the Constitution, there's really no amendment that says that we have the right to privacy. However, the courts have interpreted the right to privacy through these amendments, right? So of course, March for Life here and marches, peaceful protest. So of course, monitoring people. So, and that was it for chapter 4 in the American Government textbook of the 3rd edition from Open Stax. Thank you.